Hi everybody, I'm Jessica Kramer, a partner at Kramer, Elkins & Watt, a law firm in Madison, Wisconsin. I'm going to talk today about how to terminate a residential tenancy and make sure you're using the right type of notice. If you want to remove a tenant from a property through eviction, you first have to properly terminate the tenancy using the right kind of notice. Now today I'm not going to talk about all types of tenancies or all types of notices, just a few of the most common. The notices I'll talk about today do apply to all types of residential housing, whether it be single-family homes, duplexes, large apartment complexes, manufactured home communities, all residential rental housing. There are two main types of notices we're going to talk about, a 5-day notice and a 14-day notice. The primary difference between the two is that a 5-day gives the tenant a right to cure or fix the problem. It gives them 5 days to get caught up on rent or fix whatever the problem is, and then they can stay in the property. Whereas a 14-day doesn't give a right to cure. It terminates the tenancy, it's telling them to get out, and they can't fix the problem. There are 4 steps to determining how you go about properly terminating a tenancy using the right notice. First, you want to determine what type of tenancy do you have. There are 2 main types. One is going to be a tenancy for a year or less, and that's often under a written lease for a year. And it doesn't matter how frequently they have to pay rent as long as the lease is for a year or less. The second type is a month-to-month or periodic tenancy. Periodic can be week-to-week or some other period, but it's most commonly month-to-month. If you don't have a written lease, the tenancy is probably month-to-month or periodic. Second, determine what the default or problem is. Why is it that you want to get the tenant out? There are going to be 3 main categories. First is non-payment, the most common. Non-payment of rent or non-payment of something else that is due under the lease. The second is going to be a breach of a rule or some other term of the lease, such as having unauthorized guests stay in the apartment. And the third is a commission of a crime that threatens the health or safety of another tenant or of the landlord or agent of the landlord. Now that is very specific, and I'm going to get into more detail on the crime notice later. Step 3 is to determine the type of notice. Now that's going to depend on what the problem is, as you determine in step 2. So for non-payment, what type of notice should you issue? The first time that you are issuing a tenant a notice for non-payment of rent, it should always be a 5-day notice. In every type of tenancy, whether it's for a year or less, month to month, week to week, the tenant needs to be given an opportunity to cure the first time that they don't pay rent or some other amount due under the lease. To be clear, the right to cure is a right to fix the problem. In the case of non-payment of rent, it's the right to get caught up, get paid up. So for example, a notice might say you have 5 days to pay past due rent of $1,000. And if the tenant pays the past due rent of $1,000 within the 5-day period, they have cured the problem or fixed the problem, and you can't terminate their tenancy for that reason. Sometimes a tenant is habitually behind on rent, or they fall behind again even after getting caught up. So if non-payment happens a second or subsequent time in any 12-month period, then you can issue a 14-day notice, which does not give the tenant a right to cure. It basically says, this has happened before, we're not going to give you a chance to fix it now, you just have to get out. Of course, you can continue to issue 5-day notices for non-payment if you would like, but keep in mind a 14-day is a good tool to use if you just don't want to let the tenant keep getting caught up after falling behind time and time again. When you're dealing with a breach of another term of the lease or a rule, something other than non-payment, the analysis changes a little bit. If it's a lease for a year or less, you must give a 5-day notice the first time this particular breach happens. So, using the example I gave earlier, if it's an unauthorized guest, you need to give a 5-day notice, giving them the right to cure the problem. Curing the problem would be getting the guests out of the apartment. Also, as with non-payment, if the same problem happens the second or subsequent time in a 12-month period, you can then use the 14-day and not give them a right to cure. But here is where, when you have a periodic or month-to-month tenancy instead of a tenancy for a year or less, there is a big difference in the notices. When you're looking at a breach that is other than non-payment, so breach of any rule or term of the lease other than non-payment, you can elect to issue a 14-day notice the very first time this problem happens. Again, this is for other than non-payment. So let's say they're not supposed to smoke on the premises, and this is a month-to-month lease. The first time they smoke, you can terminate their tenancy with a 14-day, no right to cure needed. The third reason for issuing a notice that I mentioned earlier is the commission of a crime, but it can't just be the commission of any crime. It has to meet very specific elements. It has to be a crime that either threatens the health, safety, or right to peaceful enjoyment of the premises by other tenants. It can be other tenants in your building or neighbors. Or it has to be a crime that threatens the health or safety of the landlord or an agent of the landlord, so any employee or property manager, for example. If you want to terminate the tenancy for the commission of one of those crimes, then the notice is a 5-day with no right to cure. In other words, you're telling the tenant in the notice that you've committed a crime that has threatened a tenant or an agent of the landlord, and so I'm not giving you a right to fix this problem, you just need to get out. Now that you've determined what type of notice to use and the reason for terminating the tenancy, step 4 is to prepare and serve the notice. There are very specific requirements for not only what must be in a notice, but how it must be served. And I'm going to get into that in a different video. So be sure to check on back on our YouTube channel or Facebook page for a link to that video.
Can I just issue a 14-day notice to get a tenant out without giving the right to cure first?
No. If the tenancy is for a year or less, you're going to have to issue a 5-day notice the first time. A 14-day notice won't do it.
Do I have to issue a 14-day in order to evict?
Generally, no. With some very limited exceptions based upon unique circumstances, a 5-day notice with a right to cure is the notice to issue. If it's not cured, you can evict. No 14-day notice needed. So to recap, the 4 steps that you're going to go through before you terminate a tenancy are: determine the type of tenancy, determine what the breach or default was, determine the type of notice you need, and then prepare and properly serve the notice. Now, just because you've determined that one type of notice is proper doesn't mean that you're always going to serve that notice in every case. There can be other strategic considerations that come into play, including the timing and whether you have multiple tenants with similar issues. Whenever you're unsure, it's a good idea to talk with a qualified landlord-tenant attorney before serving the notice. If you use the wrong type of notice, you may get all the way to court and partially through the eviction process, and then your case gets dismissed and you have to start over, sometimes losing months in the process. Thanks for watching today. This is Jessica Kramer with Kramer, Elkins & Watt, a law firm in Madison, Wisconsin. For more information about this topic and other topics on landlord-tenant law, employment law, and other legal topics of interest, head over to our website and find Q-Tips, our blog. Thank you.